Hello and welcome to the Purposeful Wealth Podcast. At Wells Gibson, we believe wealth planning is about much more than investment returns. It's about helping families live with clarity, contentment and certainty, and ensuring that everything they value is protected and passed on in the way that they intend. Many of the families that we work with have built up significant assets over their lifetime, often through running a business or investing sensibly, and often just making good financial decisions. But with that wealth come important questions. How do you pass wealth to the next generation efficiently? How can you reduce inheritance tax? What happens if you lose capacity? And what action can be taken if long-term care becomes necessary? Well, to help us explore these important issues, I'm delighted to be joined today by Chris Gardiner of Thorntons Solicitors. Chris specialises in advising UK and international families on tax-efficient estate planning. Many of his clients are entrepreneurs and business owners, and he often works alongside financial planners, accountants, and family offices to help families structure their affairs sensibly. Chris is also an accredited member of the Society of Trust and Estate Practitioners, otherwise known as STEP, and it's the leading global professional body for specialists in trusts and estate planning. Chris, a very warm welcome to the Purposeful Wealth Podcast.
Yeah, thanks for having me on, Jonathan.
No, it's great to have you here. And although I have to say, with this lovely weather outside, I think we should be playing golf, should we not? You know. Anyway, I'm sure we'll manage to get around to golf in the very near future. Chris, maybe you could just start by maybe just following on from what I've said, give us a little idea into the work that you're finding you're doing mostly at the moment. Is there anything specifically that seems to be a real focus for you in your work at the moment?
So, as you said, my kind of area of specialism is estate planning. So we help individuals and families who have built up an asset base that's reasonably significant, or maybe they've inherited that from the generation above. I would say most of my clients are probably business owners, so it's maybe first generation wealth, and they want to look at ways as to how do they structure that in an efficient way, not just from a tax efficiency point of view, but a way that it means it will grow over the generations. It'll trickle down in their family throughout years. So there's a mix of elements involved in that. I mean, obviously over the last couple of years, the Labour government have made quite significant changes to inheritance tax. So, for business owners in particular, business property relief has been quite a hot topic over the last, say, 18 months to 2 years. So we've been working with a lot of families who own shares in private family businesses, and how do they maybe structure that to ensure that they don't have a significant tax exposure, which, not just for the sake of not paying tax, it's really for trying to minimise the impact it has on the business. I think sometimes in all the politics of these things, it gets slightly lost that family businesses are kind of the core of the Scottish economy. I think more than 80% of businesses in Scotland are family owned, at least to a certain extent. And so, for the good of the country in terms of economic activity, we need to try and ensure that these businesses continue and there's not kind of fire sales when big tax bills appear. So I would say of all the things I do, that's probably been one of the sharpest parts in terms of focus over the last couple of years.
Yeah, okay. Yeah, really, really interesting. As you say, the Labour government has certainly set the cat amongst the pigeons, particularly with regards to the pensions or defined contribution pensions being included within one's estate. But from your perspective, Chris, why is estate planning so important for families who have accumulated wealth?
Yeah, so There's probably two or three things. So at the end of the day, particularly if you're a first generation family who's maybe owned a business and is trying to pass on that business to the next generation, or you've successfully exited and you have, cash that's to be invested and structured in a way for the family long term, it's likely that people have worked very, very hard to get themselves into that position. And if they're not planning to look at the future and how that's structured for, themselves and the next generation or two, you're basically leaving it open to the legal framework that exists for that situation. And that's not necessarily what you would want. So, for instance, you mentioned incapacity at the start. So if someone has wealth and they've not done any planning, and they're intending to do that at some point in the future, if they don't have a really robust power of attorney document in place, they don't have anyone appointed who can do that planning for them. So if they become incapacitated, what their family would have to do is go to a sheriff court in Scotland and apply for what's called a guardianship order. Now, guardianships are quite limited. You've got to stand and convince a sheriff that every single power you're requesting is absolutely necessary for this person. So, what that does is it puts a burden onto your family to try and pick up the pieces, go through a court process, which is quite lengthy, quite expensive at times as well, to try and get all the pieces to be able to get your planning in place, because you've not put in the framework there to allow them to do that if you're unwell. So the difficulty with that is that there's a period of limbo there where no one can access your assets, no one can make decisions about your investments, about how your pension's structured, about whether you can transfer property, etc., etc. So that's not ideal, to put it quite bluntly. But also in terms of if you were to unexpectedly die, relatively young, and you hadn't yet done some planning to structure a will which stated who you would want to benefit, how you would want them to benefit, whether you were going to pass some assets to someone outright or whether they'd be held in trusts or other structures. If you've not done all of that, then basically in Scotland what happens is that the succession of your assets in your estate are governed by a set of rules from an Act of Parliament in 1964. Now, families, do not look the same way they did in 1964. The whole idea of kind of the nuclear family, I wouldn't say it's gone, but it's not as common these days as it once was. And people might be married a couple of times, might have children from different relationships. And so if you don't have a will in place that sets out quite clearly how you want people to benefit in your family, it will just be divided per a family tree. And the common misconception with that is that everything just goes to your spouse. And actually at a certain level of wealth, which is not that high a figure anymore, some of it goes to your children as well, and that can create inheritance tax liabilities and things straight away. So it's the whole kind of, if you don't prepare for these situations, particularly with incapacity and death, you will just get what is in the statute book, which tends to never be what people envisage they would want their family to have.
Right. Okay. And what what do you see? With that in mind, what are the biggest opportunities that families have to reduce inheritance tax, assuming they plan early enough?
Yeah, but despite changes to UK inheritance tax, or the changes that are coming in both this April and next April, you mentioned the pension changes. The UK regime, if you do an international comparison, it's not too bad. It's actually relatively generous in a sense that you can undertake some planning, and you'll be familiar, and lots of people listening will be familiar with the whole idea of the 7-year rule. So this is to do with making gifts. So you can make gifts out for your estate, and at a very basic level, what that means is if you survive those gifts by 7 years, they don't come back into your estate for the purposes of inheritance tax. So a really simple example is if you gifted £100,000 in cash to one of your children, as long as you survive that gift by 7 years, that's out for your estate. So there's no tax bill on that in the years to come. Now, there's a kind of framework around that where there are certain rules and how that all interacts, but that, generally, if you look at an international comparison, that's quite generous, and there was a bit of chat over the last couple of years as to whether the Labour government would get rid of that. If you look at Ireland, for instance, Ireland have have a tax system where you're allowed to give each child a certain amount of assets, and then they start to pay a gift tax on what they inherit after that at a certain level. And that's not uncommon in some other jurisdictions as well. So if you plan early enough, there actually are opportunities to divest yourself of some assets, pass them down either outright to children or into other kind of vehicles that you can hold wealth in, so trusts, family investment companies, limited partnerships that are structured with family members in them. So you can put that planning in place if you do it early enough. You take professional advice as to the kind of legal and tax consequences of that.
And you mentioned their family investment companies, but would you typically see these for, whereby there's at least maybe £1 million of assets that could be used?
Yeah, so essentially now you can only put about £325,000 into a trust before there are kind of tax consequences of that. On a very kind of simple level. Sometimes if you have some reliefs, there are things you can do. But for a family investment company, why they've become so attractive in recent years in particular is that you can actually put more assets into them than that if you structure it by way of an initial loan, maybe to fund the company, and then assign part of that loan over the years. So the family investment companies, because of the rules around company governance, annually at a company's house, you have to submit annual accounts. There's other bits and pieces you have to deal with. We would generally say that you would have to have a reasonably substantial investment to go into a family investment company to make cost of running it worthwhile. So the kind of the smallest ones I've seen are around £1 million or £2 million, and they're fine if the person who's creating it has the appetite to pay the annual costs associated with that. I would say they're more commonly seen where there's kind of 4 or 5 million plus of assets going into the company just because of what's involved in the annual administration. But they're a really effective vehicle in certain circumstances whereby particularly older generations can control how and when younger generations benefit from dividends being passed to them. So they're a kind of a good tool, and business owners in particular like them because if they've worked with company structures throughout their career when they've owned businesses, they understand the concept of a board of directors, they understand the concept of share classes and different rights to dividends. So that's something that business owners tend to find quite like the idea of. If they do maybe have younger children or children who are young adults and they want to maybe protect the assets from their outright ownership until they're maybe a little bit older.
Yeah. It's becoming it really is becoming a challenging issue, particularly with the prospect of pensions, private pensions being included in one's estate. But you'll be able to tell me this, but how long is it since, when was the last increase to the nil rate band, of 300, that's now 325,000?
Yeah, I mean, before my career, I think it was maybe 2008 or 2010. I would need to look it up, but it's certainly it'll be quite close to 20 years, maybe not quite that, but very, very close, I would think. And so, I think we have to accept that fiscal drag is a policy of the government.
It is. And the thing, yeah, absolutely, it is. I mean, I suppose it was welcome when they introduced the residence nil rate band, but they give you something in one hand, and then they say, but if your total estate exceeds 2 million, we're going to take the residence nil rate band away from you. And I think that, and the big challenge is there's a lot of people out there who probably wouldn't regard themselves as particularly wealthy, but they're going to be caught by this because asset prices, assets are rising in value over time, whether it be house price inflation or investment performance on your ISAs, and all of a sudden there's going to be this, huge number of people caught by the fact that the governments have just not increased the thresholds, increased the allowances. It's a real issue.
I mean, for funding of different projects that they want to implement, and house prices now in comparison to what they were even 10, 15 years ago, there's been a significant rise even in outside the big cities. And, you even look at like capital gains tax allowances and things they've been cut in recent years, and you think about the allowance sizes and when this legislation was brought in for, say, capital gains in the 1980s. So, without raising taxation, this is how the government are trying to obviously raise some more money. And George Osborne was the Chancellor at the time when the residential nil rate band came in. I don't know how many Chancellors that is now, but quite a few. And they had the opportunity to just say, well, we'll increase the normal inheritance tax nil rate band, which is 325,000. We could just increase that to 500,000. But they opted instead for a more complicated way of doing things, whereby they brought in this second nil rate that's particular to your main residence or your family home, and they said it's 175,000, but you only get it if you have direct descendants who are inheriting the property. You die with an interest in that property. You're worth less than 2 million when you die. So I think it was to try and appease probably voters in the south of England where house prices were very, very high. So that was an issue at the time, but it was a bit of political manoeuvring that has not quite done what it was set out to do.
Yeah. And one of the things you'll be well aware of, I know we've talked in the past that, aside from, the whole inheritance tax, which is obviously planning for, reducing one's liability to tax on death and ensuring that that what you own is transferred to your loved ones in an efficient manner at the right time. But on this subject, given that people are generally, we're told people are living longer, as people live longer, many families are having to face decisions around later life care. So, we've been talking about, okay, what's the tax position on death? But from a legal perspective, what planning can people put in place, or should people put in place, to make, that stage of life easier for themselves and their families?
Yeah, I mean, again, this is kind of local authority funding, so that's the squeeze on that is meaning that councils are looking to ensure that where people have what they would term deprived themselves of assets before they maybe need some kind of care facility, kind of looking at that in Scotland quite strictly. Now, obviously, there's a lot of noise about this you get in the press, and a lot of that actually is to do with the English system. The Scottish system's slightly different. I always say to people that the first thing is to kind of understand how you fund care. So in Scotland, if you need to, residential care or you need care at home, if you have the assets to fund that, if you have the income level to fund that, you are just a self-funding person. So, for a lot of people who are fortunate enough to have built up wealth, although it's sore to kind of pay the level of fees that are associated with these things, people are in the position to do that. So if they have a substantial income, maybe from pension or other income sources, they often just pay that from the income, and there's no issue of them ever having to look at other assets, because the local authority are only looking at what assets you have. If you're asking them to fund your care, and if you're funding your care yourself, they're not really interested in what assets you have. And I suppose what the difficulty comes at sometimes is if maybe there's been a couple, one of them's passed away, the survivor is left with all of the combined assets, they then move into a care facility, and sometimes most care homes now will be looking for evidence that you can fund for maybe 3 or 4 years before they accept your application. And it's only really if you can't do that then the local authority are saying, well, if we're going to have to pick up the tab for paying for this, we'd like to see that you've not divested yourselves of assets. And, unfortunately, if they deem that you have divested yourself of assets with a view to kind of depriving yourself of that capital to fund fees, they can come after family members quite aggressively. They, probably won't go into today the legalities of how that all works necessarily, but if people have structured assets years and years before into trusts and things, maybe for other reasons, there are ways that they can sometimes effectively be sheltered, but it depends on the kind of rationale when that's done. So there probably are opportunities, but they're quite limited, and it depends on the rationale at the time of doing them and how it's structured. But there is this kind of misconception that as soon as you go into a care home, the local authority are trying to sell your house. They don't have any authority to do that. They're interested in your income levels, and only if you're asking them to fund your care because you don't have the income levels do they really become interested in what assets you have to perhaps fund that.
And that becomes that becomes a challenge, because it's all very well, trying, not having enough assets so that the local authority takes care of your care, but ultimately, you would surely want to choose which care home you went to, or what I wouldn't want to be in a situation where my dear mum ended up in a care home in the future that was, not at the standard I would expect.
And that's the case when we're chatting to people who, a lot of people ask these things who have, fortunate that, we work with clients who've been quite successful usually and have substantial assets. And, I usually say to them, look, with your income levels and asset levels, this is not something you're going to have to worry about. And actually, as you say, you should be thinking about, I want the best care possible for myself or my mother or father or whatever. And that's more of an issue. I think that, I've heard of families before who've, gone to great extents to divest themselves of lots and lots of assets. And then, they realise that actually the quality of care they're going to get in a local authority funded nursing home is not what they want for their parents, and they end up simply then footing the bill for it because they won't see their parent, sit in a quite grubby kind of care home somewhere.
Yeah, sure. And on the subject of, on coming back to the whole point of estate planning, Chris, perhaps just for anyone watching and listening to this, you could explain why wills and powers of attorney are such a critical part of good estate planning. And I only ask this because I'm amazed how many adults, I hear of adults in the UK who still don't have wills and haven't arranged powers of attorney.
Yeah, I mean, the stats are, I suppose, quite alarming. But I suppose I have a kind of unique view on that because I see how difficult it can be at the other end. So I think recent stats I've seen is that it's less than less than 50% of people would have a will and power of attorney. I mean, in Scotland, obviously, we have different rules than in England and Wales, and touched on it earlier that if you die without a will in Scotland, there are certain levels of different asset classes and the way your estate is divided. So your spouse is entitled to a share of your property up to a certain value. They're entitled to cash up to a certain value, depending on whether you're survived by children. But then everything after that is basically divided between a spouse and children. And so you can end up with some pretty messy situations, and we do see them where people have kind of wrongly assumed that their spouse will inherit everything or their children will inherit everything. And depending on the family circumstances, that doesn't happen. And what it often does is, if you have a married couple, it sometimes means that there's an inheritance tax bill on the first death. So not only are they not inheriting all the assets, they're actually having to pay a tax bill as well because their children are having to pay some of them. Now, there are ways to try and vary the estate to get around that. But essentially what it means is that it's a much, much more labour-intensive and, quite frankly, expensive process than if you have a clear will in place that's been professionally drafted that says, when I die, I want these people to be the executors who are in charge of winding up my estate. I want these people to benefit in this way. And that's pretty robust. That is what will happen. So if you have a good will, you knock out all of what we call the rules of intestacy, which relate to the family tree and the rules from 1964 that I mentioned. The only thing on top of that can disrupt that in Scotland is that we do have some what we call forced heirship rules. We have what are known as legal rights. So a spouse and children, if they're not included in your will, do have certain rights to make claims over your movable estate. So not the value of any kind of land and heritable property, but the value of cash, investments, items you might have that are movable. And so that's the only thing that can disrupt a will. So if there is maybe a family fallout and there's a child that someone doesn't speak to, they potentially do still have a claim on your estate in Scotland, even if you have a will. But actually, if you engage early when you're making that will with a lawyer, they will explain how legal rights work to you and what planning options you might have to mitigate that risk. Whereas if you just do nothing, you're going to get hit with the rules of intestacy, which, I don't think I've ever seen an intestate estate where the outcome is what the family had envisaged or wanted. So if you plan early, you get all the benefits of that. And that's the same with the power of attorney. So I mentioned guardianship orders earlier. If you become incapacitated and you don't have a power of attorney in place, your family have to go through a court-based process to be appointed to officially manage your financial affairs and to make decisions about your welfare on your behalf, so about medical treatment and where you live and things like that. If you put a power of attorney in place in Scotland, you can put in place what you call a continuing and welfare power of attorney. Now, the continuing side deals with your finances, so it allows your attorneys who you've appointed, who might be your wife and or your children or your husband, it allows them to make decisions about your banking, about dealing with paying bills on your behalf, everyday admin tasks, buying, selling property. But more commonly these days as well, if you have one professionally drafted, you'd have powers in there around doing tax planning on your behalf, making gifts on your behalf, dealing with inheritances that you might have. And then on the welfare side, it would cover off, where you live, what you eat, how you dress, who you socialise with, what medical treatment you receive. So if you have a power of attorney in place where you're appointing your family members and you're saying in advance, I want these people to make these financial welfare decisions for me if I become very unwell in the future and become incapacitated, that document can be registered and then used immediately by them if you're in a bad accident or become unwell very quickly. Whereas if you don't have that in place, they have to at that point go through that court process where it does leave your affairs in limbo. And it can have quite, in terms of being able to manage investments and things, depending on how they're structured, it can have quite disastrous consequences for people's finances.
And when it comes to wills, Chris, is there best practice in terms of how frequently a person should review their will?
Yeah, there's probably not one size fits all. I would say generally we say to people every 3 to 5 years, or if there's a major life event. So if you have children, if your children have children, you become a grandparent. If you're divorced, if you're buying or selling a business, if there are kind of significant life events, you should review your will to make sure it still is in line with your wishes. But we would say generally every 3 to 5 years, it's good to reach out to your lawyer and review it anyway, just because there might have been changes in legislation in relation to how your will is structured. There might have been tax changes, for instance, the inheritance tax changes that have happened or on the horizon. And so just keeping that under review means that you're getting the most up-to-date information about what is best for your circumstances. It's not uncommon to see people making a will when they're maybe in their late 20s and they're buying a property, and then you don't see them review it until maybe their children are 20, 25 years later. Usually that's okay, but you can miss opportunities if you don't keep it under review.
Yeah, okay, thank you. No, that's very, very helpful, because we do find that, regularly when we meet clients, and you find out that they arranged their wills when they were married, and since then there's been children and grandchildren, and they've never, I don't even think they know where their will is. There's often another challenge that we seem to come across. And, from your experience, Chris, we said at the outset that you have experience in advising, the entrepreneurial families, from your experience advising entrepreneurial families, what in your opinion helps wealth pass successfully to the next generation?
There's probably the main things. I think engagement between the generations. So, if there is a good dialogue between the generation that maybe has if it's the first generation wealth or the inherited wealth, and the generation below them, if there's a certain time when children are old enough and maybe are adults themselves, if there's a frank discussion about the purpose of that wealth, coming to the title of your podcast and kind of, what is the purpose of that for the family? The kind of the story about how it's been acquired. If there's a kind of frank discussion and engagement about why it's structured in a certain way. So, there might be discussion about why there are shares in a family business and trust, and they're not going to be passed on to you as the child outright. And maybe that's because of certain tax reasons, certain tax benefits for the family as a whole. It's maybe a protection element to protect those shares from being owned outright, so that if someone in the next generation was to maybe get divorced, or to be involved in a separation if they were cohabiting, then those shares have a bit more protection from being involved in any financial settlement. So I think like at a very fundamental level, at the right time and in a kind of structured way, if there's a healthy kind of engagement, that always sets the tone really well. And I think also just being quite frank about the risks involved. So, we often help families kind of navigate that discussion between generations, where we're saying to clients, look, you're going to pass over this wealth to your son or daughter. We don't know how their relationship will be in the future. But my advice to you as a legal professional is that you should ask them to enter into a prenuptial or a postnuptial agreement with their spouse or civil partner, because we want to make sure that these assets that they're going to inherit outright, if the nature of those assets change throughout their marriage, we don't want any argument, if there is a breakdown in the marriage, that this family wealth that's been acquired is part of the financial settlement. We want to make sure that that's separate, because maybe if that is shares in a family company, we're then going to have to find liquidity to find the cash to deal with that financial settlement, because the shares won't be transferred. So they're quite difficult conversations between generations, because quite often parents think they're then prying into the marriages or civil partnerships of their children. And so that's, I suppose, where, having professional advisors comes in, that we can structure a meeting and say, look, this isn't your mother or father's idea. This is the advice we're giving them. This is the best thing for the protection of the family wealth. It's a matter for you as a family to discuss how you do that. But this is the best advice you're going to get, and here's what it is. And you kind of sit in the room and you're the one that everyone can point at and blame, and that's your job in that situation. So yeah, early engagement, ongoing discussions, annual reviews. Sometimes if a decision's been made and there's a certain level of wealth involved, we will maybe structure a document like a family charter. So a family charter is just an agreement, if you like, between different generations of the family, saying, here's all these kind of fundamental principles that we're going to sign up to. We're going to sign up to, as a family, trying to be tax efficient, trying to protect the assets from divorce and other potential issues. And that's quite a good way if you have had a discussion as a family and you have agreed certain things, you write it down and you all sign it. Not because that's necessarily a really enforceable document in a court, but it's a record of a decision. And if you go 5, 10, 15 years in the future, recollections may vary of what was agreed, but if it's written down, then you've got the basis to have a kind of civilised conversation about it.
Yeah. That's very helpful. I really love that idea of the charter. I think that's a great thing, isn't it? Just setting down why, what's prompted a particular decision. Great. And, and you're absolutely right. Conversation is key. Just communicating with the family, and as you've said, involving other professionals. Have a meeting that involves your lawyer, your accountant, your financial planner is going to be critical in all of this, isn't it?
Absolutely.
Particularly for these entrepreneurial families. I suppose there's so many questions.
Yeah.
I think we could probably run a series of episodes on this subject, taking one thing at a time, whether it be lifetime gifting or an episode on trusts or family investment companies and all the rest of it. But hopefully today is or this episode is will prompt viewers or listeners to at least get their will done, I guess, or engage with in some professional advice. I mean, my final question, I suppose, is that if someone is watching or listening to this episode and hasn't done any estate planning as yet, what's the one step they should take first, Chris?
Yeah, I always describe estate planning to people as kind of two lines. So there's a line up at the top, which is your estate plan, and that's if everything goes well and you live long enough to do all the lifetime planning you want to do to structure your assets in the way you want to do. But I always talk about the kind of the line below that being there to catch and bring it back up if things don't go to plan. So I always say to people when we first meet, look, let's get a will and a power of attorney in place. Let's get the basic fundamentals in place so that once we chat and create an estate plan and work on that over a number of years, if you become incapacitated and you can't finish that estate plan, your powers of attorney can do that under your power of attorney. If you unexpectedly pass away before you've got to the end of that estate plan and you've not managed to do the gifting or structure the estate planning right until the end, then in your will there's a soft landing. Maybe if it's a first death between spouses or civil partners, there's a soft landing for inheritance tax purposes, so we can pick that back up and continue on the estate plan. So I think those basic fundamentals would be the will and the power of attorney, and then you have a more detailed discussion from there about, well, what can you do before it gets to that point, and you can start to structure a plan to slowly and in a controlled way reduce your wealth and pass that down to the next generation. But at the same time, making sure, and this is of course where you come in, Jonathan, making sure that they have enough to have a comfortable life, they have a nice income, they have a capital in the background to make sure that if they do want to do all the things they planned in retirement, there's money there. There's a balance between those two things.
Yeah, there is, and it's exactly the role that we do play in when it comes to estate planning, particularly around whether it's establishing a trust or being able to answer those big questions that many clients have. You know, how much is enough, or how much could I afford to give to my children without running out of money? You know, they're the sort of big questions that we love to help answer. Chris, look, as I said, there's so many things we could talk about today, but I really just want to thank you, so much for joining me in today's episode. It's very much appreciated. And as we've said, estate planning is something many people put off, but as we've discussed today, good planning can make an enormous difference, not just financially, but also in terms of clarity and peace of mind for families. If there are any viewers or listeners that would like to learn more about Chris and the work that he does, or the work his team does at Thorntons Solicitors, we'll include those details in the show notes. And if you've enjoyed today's conversation, please subscribe to the Purposeful Wealth Podcast, where we hopefully explore the ideas and decisions that help families live with clarity, contentment, and certainty. Again, Chris, thank you so much for joining us, and I'm sure we will at some point speak again.
Yeah.
Thank you.
Thanks for having me. Cheers.